Great. So I think the trickle of attendees has slowed down a bit, so I think we can get started, but I'm sure people will join us as we go along. But yes, good evening, everyone. Thank you so much for joining the Human Rights Lawyers Association's Roundup event and our review of the year in human rights, which will be followed by our annual general meeting at 7. My name is Zehrah and I'm the Vice Chair of the HRLA, and I'm also an immigration and public law barrister at Garden Court Chambers. I'll be chairing the first part of this evening, and I'm delighted to be joined by an expert panel of human rights lawyers who have been relentlessly fighting the suppression of our rights on the front lines. We are so grateful to have them here today, given their extremely busy practices, particularly in the current climate, which I'm sure we'll talk about a lot tonight. We will be hearing from the brilliant Chada, Toufique Hossain and Sara Lomri in due course. However, I first wanted to do a bit of housekeeping and then provide a brief introduction to the topic this evening, namely a review of the past year in human rights, and it's definitely been a busy one. But in terms of the practicalities of tonight's event, the HRLA is extremely grateful to Doughty Street Chambers for providing the online facilities to host this session. If you do have any technical difficulties during the discussion, please do try to just rejoin the event and we should be able to let you in immediately, or get in contact through the contact details that have been posted in the chat box. If you want to tweet about the discussion tonight, please feel free to do so and use the hashtag HRLA review. So the event will start with each speaker discussing their reflections of the past year for around 10 minutes each. There'll then be time for me to ask the speakers some questions, and then we should have around 15 minutes at the end for questions from the audience. Please do think of any questions that you may have for our expert panel, and please try and post these questions in the Q&A box. So if you go on more or you look at the bottom of your screen, there should be a Q&A option, and so you can post any questions in there. And I can keep track of those, and then I can pose them to the speakers at the end. The event will conclude around 7 p.m, where I will swiftly hand over to the HRLA's chair to deal with our AGM business. So on tonight's topic, I think it is no understatement to say to any people here that the last 12 months have seen some of the most authoritarian and draconian efforts by this government to suppress our human rights. A raft of draft legislation has unfolded, from the Judicial Review Bill to the Police Crime Courts and Sentencing Bill to the Nationality and Borders Bill, as has a renewed attack on the Human Rights Act through the government's so-called independent review. Not only are these threats to our fundamental freedoms making their way through Parliament, but we've continued to see a hostile discourse surrounding human rights in parts of the media, by politicians of all colours, and within sections of the public, particularly when it comes to race and migration. The combined effect of all of this legislation and political grandstanding results in a concerted effort to undermine the rights of many, including asylum seekers, Black, Brown and GRT communities, LGBTQ+ people, people with disabilities, and many more marginalised groups. And the most egregious part of what this state is currently pursuing is the fact that it is also trying to shield itself from accountability and from every one of us having the ability to challenge policy and parliamentary decisions we disagree with. And it's doing this by narrowing the scope of judicial review and trying to criminalise most forms of protests, which intentionally aims to prevent us from effectively challenging this government, both in the courts and on the streets. But amidst this massive power grab, we are also seeing thousands of people across the country come together, mobilising and organising to grab the power back. Groups like the Kill the Bill Coalition, Sisters Uncut, migrants' rights and racial justice organisations across the UK have sought to highlight issues like why the police do not need more powers, why our border regime remains racist and cruel, and how we can collectively resist this authoritarianism through activism, through policy work, and through the law. And that is why I'm so excited to have with me today 3 speakers who have absolutely been at the forefront of this fight, defending protesters, fighting for migrants, and holding the state to account. Their insights and reflections, I'm sure, will serve as a valuable tool to all of us to consider what more we can do as human rights lawyers to resist the destruction of our freedoms and battle for our collective liberation. So I think that's the perfect point to introduce our first speaker, Raj Chada, who is head of the criminal defence team at Hodge, Jones and Allen. Raj is one of the country's leading criminal lawyers and one of the most experienced when it comes to defending protesters in the criminal courts. 2 examples: Raj successfully acted in the Stansted 15 case, which saw all 15 defendants cleared of terrorism convictions in the Court of Appeal almost exactly a year ago today. And more recently, Raj acted for the Colston 4, who removed the statue of a slave owner in Bristol, securing acquittals for them. Raj has also been excellent at providing me with direct support when I found myself in bother at protests. So given his expertise, Raj is going to cover the expansion of police powers we've seen over the last year, and in particular, the crucial and many developments in protest law. So I'll hand over to you now, Raj.
Thank you very much, and thank you for the introduction. The Colston 4 trial still gives me a smile every time someone mentions it, and it's not often a criminal lawyer can say that about one of their cases. It's been a whirlwind year in the world of protest. It's been like a tug of war where human rights have been tugged one way and another, and I suppose not even a tug of war in the normal sense, but a multi-dimensional tug of war between the government, the executive, the judiciary at all levels, the Supreme Court, the Court of Appeal, and at first tier, activist groups, and the public perception of all of this. It started in a way through a case that many of you will probably already know about, but the case of Zehrah, which was decided in the Supreme Court in June. Zehrah revolved around the facts of Zehrah related to a group of peace activists who had laid down in the street outside the arms fair in East London and had blocked one of the entrances to that arms fair. They were charged with obstruction of the highway, and they were acquitted at the Magistrates' Court as the district judge found that the prosecution couldn't show that their conduct wasn't reasonable or didn't have a lawful excuse. And so they were acquitted on Article 10 grounds. Prosecution appealed, divisional court overturned that conviction, but set out a clear framework about how human rights should be used in these sorts of cases. But we took it to the Supreme Court, and there were 2 certified questions, both of which have profound consequences in criminal law for how human rights are applied. The better known question was about whether deliberately physical obstructive protests are capable of having a lawful excuse under an obstruct highway charge, i.e. would Article 10 and 11 cover potentially that conduct? And secondly, it was what the test was for an appellate court to an assessment of the statutory defence where convention rights were engaged. Dealing with the first of those, and the Supreme Court held quite clearly that it was capable of being a lawful excuse. Didn't mean that it always would be, but it was capable, and that it applied not only to obstruct highway, but that should apply to a range of public order offences. that you needed to conduct the normal exercise when looking at convention rights. Is the right engaged? Has it been interfered with? Has it been interfered with for a purpose in accordance with any of the subsections on 10.2 or 11.2? And then is it necessary in a democratic society, or the proportionality exercise? And what that came down to really was what the court was saying was that you had to balance the rights of protesters versus the rights of others. A familiar sort of topic to human rights lawyers. And that's consistent with the Strasbourg legislation, or the Strasbourg case law, but hadn't really been said in such terms in the UK, where it was still about a highway being primarily to pass and repass. So it was a groundbreaking judgment. And even more importantly, it was clear that the Supreme Court said that that issue of proportionality was for the jury to decide. And that opened the door in a way to a number of cases that followed. Cases in relation to Extinction Rebellion, cases in relation to Black Lives Matter, about how that would be used in the context of criminal trials. I'll return to the second certified question at the end, because that may have profound implications in future as well. But various protest groups still conducted these cases, went to trial, often in the magistrates' court, sometimes in the Crown Court. And that's where the tug of war started, which was, well, how far does Ziegler apply? In what circumstances does it apply? And at the same time, Extinction Rebellion set up more protests, which were deliberately obstructive. And we had the Black Lives Matter movement as well, in those cases going through the court. What's interesting, and just diverting away from the courts for a second, is the government response to all of this. Not to Ziegler, because they'd set in play some of this beforehand, but it's interesting that the Police and Courts Bill was specifically, and the Home Office were quite clear at the time, was specifically designed to deal with Extinction Rebellion protests, in particular the press action protests, where a group had blocked the entrance to Rupert Murdoch's printing press and stopped copies of The Sun and The Times going out, and the Black Lives Matter protests. And before we get into the bill, that is an astonishing, it's an absolutely astonishing admission by the government that they were legislating because of protest rights which were being exercised by their political opponents, and they wanted to shut those protests down. And that's the background to the current bill, and that's only one reason, we'll get into the detail of the proposed legislation, why it's so controversial. But I think that gives an insight into the current government and their mindset. The press action case was quite interesting as well, because during the course of the trial, it emerged that the Home Secretary had been directly in touch with the commander, the Chief Constable of Hertfordshire Police, throughout the night, demanding that these protesters were removed. Again, quite an astonishing issue for a member of the executive to interfere, we say, with the operational independence of the police during the course of a police operation. And we ran an abusive process application in relation to that and used the Ziegler defence as well. We've lost in the Magistrates' Court, that's going to the Crown Court in appeal, and we'll see how a Crown Court judge will deal with it. But that was one example of where Ziegler was applied unsuccessfully. The example of where Ziegler was applied successfully, it's not the first time it's been applied successfully, it's been a number of occasions, but clearly the most famous example was the Colston 4 case. So in Colston 4, we argued that firstly, that they were preventing a crime from occurring. and that they had honestly believed that a crime was occurring, and that they used reasonable force to stop that crime. The crimes being an offence under Section 5 of the Public Order Act, or that the statue itself was indecent or it was abusive to others. And secondly, we indicated that they had a lawful excuse under the Criminal Damage Act because of Ziegler, and that meant that the jury had to take into account whether a conviction would be a proportionate interference with their right to free speech and their right to assembly under Article 10 and 11. Now, that wasn't even contested by the prosecution as an issue. They looked at the Supreme Court judgment in Ziegler and indicated that, as far as they could see, that was absolutely an issue that had to be left. Those were issues that had to be left to the jury. And so it's somewhat surprising the level of outcry about the jury decision. Although it was a majority verdict, the jury took 3 hours, just over 3 hours, to decide after a 2.5 week case. And I thought that gave a flavour as to where they are. But this tug of war is still going on. We've recently had a Court of Appeal decision in the case of Brown, who was the Extinction Rebellion activist who stood on top of a plane and was charged with causing a public nuisance. And there are various legal arguments about how Article 10 applied in that case, which broadly the Court of Appeal rejected. And that only came out last Friday. It's going to be interesting to see where we go next. It's going to be interesting to see how the government respond to these continued protests and how we test the convention rights that Ziegler outlined should the bill come into force, because they're clearly in direct conflict. One tries to outlaw disruptive protests to a greater extent, and the other is indicating that disruptive protests are capable of protection under Article 10. So that is a very, very quick run through of a very busy protest year.
Thank you so much, Raj. That was really insightful. And yes, I think that push and pull is something many of us are seeing, and I'm sure will resonate with the work our next speaker does as well. So our next speaker is the formidable Toufique Hossain. Toufique is the director of the public law team at Duncan Lewis. He is a leader in his field and has been at the forefront of many strategic challenges brought against the Home Office on behalf of asylum seekers and migrants. His practice is dominated by judicial review, leading strategic litigation, where he represents both individual claimants and NGOs who seek to challenge executive decisions, policies, and practices. His career began representing asylum seekers in international protection claims before developing a wider judicial review practice, which grew from seeing the wider issues that were causing his clients substantial and systemic prejudice. Toufique works at the sharpest end of injustice in our immigration system, from the detention estate to mass deportations, and he will be speaking about how these battles have progressed over the past year and the key developments in migrants' rights litigation. So I'll pass over to you, Toufique.
Thank you, Zehrah, and thank you for inviting me. I really need to shorten my DL profile, don't you? That was very long. What I want to cover today, I mean, it's been it was a long year for immigration asylum in terms of the cases that came out, in terms of how our clients were affected. So I want to kind of very quickly breeze through what I think were some of the highlights and some of the important issues. I think last year continued to see the relentless attacks on civil liberties and human rights. The experience of our clients kind of very much confirmed the very real existence of the hostile environment. And the year saw the announcement of the terrifying Borders Bill, the Judicial Review Bill, and the Human Rights Consultation, We also saw further stark examples of the government's desire for really oppressive policies, some that were announced, I think, for political effect, but some that are very real. The ongoing attacks on refugees trying to enter the UK by small boats continued. The government pressing for prosecutions and their attempts to stop the crossings culminated in the formulation of a pushback policy that is currently being challenged by our clients in the courts. Any attempt at helping these deeply vulnerable refugees are met with tags like dinghy chasing lawyers, with the Secretary of State aligning us with smugglers and gangs. We've seen several UK Supreme Court decisions last year on various immigration issues. This includes the Shamima Begum case on citizenship deprivation, and ones that affect strategic litigation like BF Eritrea and A, on what they believe to be the right approach to judicial review of government policies in general. I think it's worth reading Conor Gertie's excellent article recently on the Supreme Court, saying in respect of the current president, I quote, "In some areas, the tone is markedly different from the one taken by the court under Hale's leadership. This has been clear in a series of decisions that have been very helpful to government on issues of equality, social policy, and human rights." Going back to the Channel crossings, one major issue last year was the absence of Dublin Convention removals. In 2020, we were really busy stopping so many removals back to EU countries because of Brexit. The Secretary of State can no longer remove on that basis anymore. I think the government has successfully, managed to sidestep the inconvenient truth and ramp up that hate towards refugees and those who help them, because they just don't have any plans. The new inadmissibility rules were due to commence in January 2021, and people, our clients, received notices of intent which delayed substantive consideration of their valid asylum claims. That kept them in temporary accommodation paid for by the taxpayer. We've seen real delays in asylum claims because of that nonsense, and we know that for that to work, the government had to basically agree deals with third countries, and they've failed thus far. It's important to note that the delays that we see, also due to the pandemic, have had a really horrendous effect on our clients. A lot of our work last year was getting people out of woeful temporary accommodation in hotels and in barracks. Mothers and children having to stay in really shocking conditions, torture survivors and genuine refugees in de facto detention in army barracks, being told that they are free to leave, only to be met by far-right racists on the other side of the barbed wire fences. We've seen again with these delays how unfair it is that asylum seekers can't work, and we are making some inroads through legal challenges in that regard, but it's not enough. Again, asylum support continued to be inadequate. There was some positive advances, mainly for trafficking survivors, but in general terms, the current support levels are pretty dire. The government's policy on charter deportation flights continued, places like Jamaica, Vietnam, Zimbabwe, in my view, destroying families, young children's lives. We succeeded in stopping many removals, and Priti Patel, in her conference speech back in October 21, said, "Even when seated on a plane, their lawyers can block their removal." Said with utter disdain, although the reality is that the Secretary of State deferred removal in most of our cases, and the flights exposed serious failings on the part of the Secretary of State's decision-making process. We saw the Brooke House inquiry began, which is a big deal. It's the UK's first inquiry into immigration detention, and we're hoping that all the testimony and all the reports will give a true insight into immigration detention and indefinite detention and its dehumanizing effect, and that continues next month. It's been around 20 years since the Yarlswood Detention Centre, the Women's Detention Centre, was operational. And I remember back in 2008, representing a woman, a survivor of sexual violence, detention clearly harming her, winning her case, and thinking back then, surely they'll end this sort of detention, But in December 2021, the Home Office opened a new women's IRC. I think from our point of view as immigration asylum lawyers, 2021 was pretty much similar to 2020. Attacks from all angles, government, right-wing extremists, the press. It's harder than ever, I think, to bring challenges to the court, given how politicised this all is. It has a chilling effect. It has a knock-on effect on our energy and stress levels. But, I guess taking on government and such an oppressive one, and sometimes winning and being able to make a difference for your client, well, I guess that keeps us going for 2022. Thank you.
Thank you so much, Toufique. Yeah, that was also really insightful, and definitely agree. So much has happened, but and a lot of it has been very difficult to face, but agree we have to keep fighting into this year and beyond. Our last speaker is Sara Lomri. Sara is a solicitor and the Deputy Legal Director at the Public Law Project. She joined PLP from Bindmans in 2016, where she had established a highly regarded practice in public law and civil liberties. She also has a long history of leading campaigning and lobbying work. Sara now works on PLP's strategic legal challenges against state departments on wide-ranging issues engaging access to justice and state accountability. She's been at the forefront of scrutinising the government's proposed reforms of judicial review, as well as the sustained attacks on the Human Rights Act. And her team do vital work using administrative and public law to hold the government to account. Sara is going to examine the ongoing threats to the legal mechanisms so many of us rely on to counter the state's authoritarian agenda, and the ways we can protect these in the face of an ever-shrinking space for resistance. So, Sara, I'll pass over to you now.
Thanks so much. That's such a kind introduction, and it's so nice to be in such lovely company, despite the kind of the outside gloom. So yeah, I'm talking about judicial review and HRA and how they've changed and been used in the last 12 months. I'm currently a bit obsessed with the JR bill, which is going through Parliament. So I'm sorry if it's I'm a bit skewed, a bit focused on JR reform above HRA reform, but hopefully I'll kind of do both a bit of justice. So firstly, sort of want to talk about the official constitutional reform that's going on. And so obviously that started, certainly for the purposes of this story, with the independent review on administrative law. That panel was established by the government in July 2020, so that's just over a year ago. And certainly by me and PLP and lots of others, it was seen as the first step in this government implementing page 48 of their 2019 official Conservative Party manifesto. And I'll just remind you what that said. It said, once we get Brexit done, Britain will take back control of its laws. After Brexit, we will also need to look at the broader aspects of our constitution, the relationship between the government, Parliament and the courts, the functioning of the royal prerogative, still hurting from Miller, the role of the House of Lords, and access to justice for ordinary people, so on and so forth. We will update the Human Rights Act and administrative law to ensure there is a proper balance between the rights of individuals, our vital national security and effective government. We will ensure that judicial review is available to protect the rights of individuals against an overbearing state while ensuring it is not abused, importantly, to conduct politics by another means or to create needless delays. In our first year, we will set up a Constitution, Democracy and Rights Commission that will examine these issues in depth and come up with proposals to restore trust in our institutions and in how our democracy operates. And of course, many of us working in this space felt that it was a good opportunity for the government, or they thought it was a good opportunity to put judges in their place after the Miller II prorogation decision of the Supreme Court a bit of kind of an opportunity to come up with the much loved flag waving Bill of Rights, and also to stop apparently campaigners from using JR as politics by another means. So I'm going to go into a little bit about IRAL because I just think it's so important, and to sort of track how this reform is being pushed through Parliament. So the IRAL was chaired by Lord Fawkes QC, who was a previous Conservative government minister. He was assisted by 6 individuals, and it's important to note, well, it's important for me, I think, to note that those individuals were, although like fantastically successful and brilliant current or former legal practitioners and academics, none of them are individuals that I would, or maybe we would, recognise as really understanding claimants' experience of JR or anything like a kind of legal aid, working legal aid system. And despite that, they came up with some recommendations that perhaps the government didn't expect. We'll get into that. So one of the main issues that PLP talks about, and has kind of become a bit of a personal obsession as well, is the lack of evidence-based, and of course the importance of evidence-based policy development, but the lack of evidence around JR. So there is so little to know publicly available data on who uses JR, what JR costs, whether meaningful access to JR is currently being provided. And of course we have our own experience as practitioners. We can listen to Toufique and the kind of incredible, inspiring work that he does, but we know that JR is used by a kind of wider spectrum of people, but we don't really know what the stats are, who really is using JR, and what does it cost, and what does it cost the government, importantly. And as Lord Fawkes said at the beginning of IRAL, so little is known about what the government thinks about JR, and this was a really good opportunity to find out. He sent out questionnaires to central and local government departments, asking them to explain how judicial review impeded their functions and made their decisions less effective, because that was the accusation. And really what we've seen from the report that's been published is the answer is it doesn't. Judicial review doesn't really impede our functions or make our decisions less effective. Most of the IRAL submissions have been published, but not the 15 separate individual government departmental submissions. And if anybody wants to ask a question and wants to ask me what PLP is doing about getting those submissions into the open air, then please go for it. But I don't think I can take up any more time on that. So IRAL did a good job in the time available. They had 6 months beginning to end, and they were reliant obviously on submissions, and there's no way that organisations like PLP or the Law Society, or even, for example, HMCTS or the MOJ, the organisations that actually have the important data, could collate the level of or the kind of empirical evidence that we think would be needed to undertake a really useful review of administrative law. But we and many others did our best. IRAL reported in January 2021, so exactly a year ago, and sorry, my dog's barking at me, thank you. And actually IRAL's recommendations were really restrained. The Lord Chancellor at the time, Robert Buckland, misrepresented IRAL's findings to Parliament, and also regularly to the press at the time. And Lord Fawkes corrected him in an interview with Joshua Rosenberg, and he said, I think actually we found that there were 1 or 2 cases which we particularly pointed out where there was considerable tension between what was legitimate to be considered by the courts and what was really a matter of politics. But those were particular cases. We did not think that there was an overall trend that you could extract from those particular cases. And our submissions, and they were mirrored by lots and lots of other sensible organisations, was basically, when it is available, JR works well and functions and is an important check and balance, and actually there isn't a problem that needs fixing. But as Lord Fawkes termed it, the consultation and the bill that's now in Parliament very much feels like a solution without a problem. I was going to do a bit about how I wonder if Lord Fawkes, if given the opportunity again, would take that job again. And we know as well, I'll just mention quickly that he, in interviews, Joshua Rosenberg indicated that there, Lord Fawkes indicated that there was a bit of horse trading that went on at the conclusion of the report stage, where the MOJ agreed not to amend his findings in return, potentially for not publishing the government submissions. So question marks there, and again the kind of government trying to put themselves beyond transparency, beyond accountability. In short, the bill that's going through Parliament at the moment covers lots of things. I'll just talk very briefly about clauses 1 and 2. Really, just clearly, if this bill is passed as it is, the JR and the JR and Courts Act will make this and future governments less accountable, absolutely echoing Raj's comments on the government shutting down those that challenge them. So briefly, clause 1 focuses on prospective only and suspended quashing orders. So it basically, sorry, I'm just trying to make it as quick as I can. So clause 1 of the bill creates a presumption that a judge issuing a quashing order should make it suspended or prospective only. So suspended until a date, or suspended until invariably defendants, the government's action. So prospective only means that the unlawful action is only invalidated from the point of the court order onwards, and this leaves past conduct, including the conduct complained about by the claimant, untouched. And you can see how, with a presumption for suspended prospective only quashing orders, we really quickly get ourselves into a pickle. State sanctioned, essentially unlawful decision making is law. We get into confusing legal scapes. Public authorities are insulated from being held accountable until a court order, so it doesn't act retrospectively. And essentially, it really calls into question whether claimants bringing JRs have effective remedies, as well as undermining judicial discretion, etc. Clause 2 abolishes an important judicial check against errors made in the tribunal system. They're called CART JRs. I think the real headline about them is that the government have said this is a blueprint for us introducing ouster clauses in future. So other areas of government decision making which are immune to judicial review. So this is a blueprint for ouster clauses. There's a lot to be said about the high courts, how high courts have dealt with ouster clauses in the past, and those who've been working long enough remember all the Privacy International stuff and the IPT work. CART JRs are mostly used in immigration and social security cases, and we say that by clause 2, by abolishing CART JRs, you would remove legal protection from those who need it most at the time that they need it most. Although helpful amendments to the JR bill have been tabled by Vera Hodge and Andy Slaughter, I personally wouldn't put any money on them getting through. In the meantime, the Independent Human Rights Act review was set up in December 2020. And again, they've been asked to look closely at the relationship between the judiciary, the executive and the legislature, as well as the relationship between domestic courts and human rights, and the European Court of Human Rights. And they've come, again, exactly the same as the IRAL, come out with some actually fairly unheadliney recommendations. They've talked about the need for public legal education around human rights. Yes, absolutely. They do talk about priority of rights protection, i.e. domestic statute first before interpreting a convention right, etc. But absolutely, I think this is a sense of déjà vu, and the government's finding solutions for problems that don't exist. The government's HRA reform consultation is currently out and open. The deadline is the 8th of March, and I'd encourage you to consider responding. Our general take, PLP's general take, is that the HRA is a balanced piece of legislation that has protected rights to a greater degree than common law and has kept the UK compatible with the ECHR, whilst also respecting respecting British constitutional fundamentals like parliamentary sovereignty. In relation to the HRA reform, I'd comment that the policy win that the government seemed to really be targeting or hanging out for is against foreign national prisoners, and obviously massive concerns that not only they would not be given protection, but also the kind of significant Article 8 price that we'll pay for that. There's also, as many regressive governments do, it feels like they are, by looking particularly at Article 8, Article 10 tension, it feels like they are trying to kind of pit equality groups against each other, with them winning ultimately by introducing regressive laws. Overall, I'd comment that whilst we deal with this huge amount of constitutional upheaval, it feels like our objective is really just trying to protect the status quo rather than improve it. And that really is something that we really need to remember and keep hold of. I just really wanted to briefly touch on the SC decision, the two-child tax benefit case from the Supreme Court from last year, but I just wanted to know from our lovely chair, if I can.
Yeah, go for it,
Thank you. So there's a question. So we've got some sort of formal constitutional reform, no shortage of it going on. And then we've also got the kind of change in judicial decision making, and Toufique flagged that, and the difference between the kind of Hale Supreme Court and the Reed Supreme Court. And I think in kind of thinking about that, firstly, I would say it's really hard to ignore anecdotes that decision making in the High Court is getting tougher on claimants. My personal experience has been that I've had negative permission decisions in the last year on admittedly ambitious kind of systemic cases that probably would have got through 2 or 3 years ago. Whilst it's important, I think, to note these and for us to be able to advise our clients in their best interests as a result of that, it's also, I think, really important not to internalize too much of that chilling effect, and kind of for us to self-censor ourselves as well. I think that there were cases that you could identify over the last year that point many ways, and I don't think that there's a consistent narrative to be told about regressive, restrictive, anti-claimant decision-making from the judiciary, but I do think that the SC decision is really important, and I will put the citation in the chat when I'm done. So that case is about the two-child limit, and the judgment was published in July 2021. The rule under challenge meant that families claiming child tax credit or UC, universal credit, were limited to claiming for 2 children only, for children born since 2017. So 2 lone mothers and their children were the claimants, and they said that the rule discriminated against children, large families, women, and those with a religious or moral objection to using birth control. They also said it breached Article 8. Interestingly, the defendant, so the Secretary of State for Work and Pensions, and the claimants agreed that although it was couched in neutral language, the rule, the 2-child limit, affects women more than men. And when looking at whether the difference in treatment between men and women and between children in smaller versus larger families was justified, as one does when you're looking at in a discrimination claim, the court decided on 3 issues of general importance, which I think are really kind of, for me, big standouts from last year in terms of HRA development. So the first is the court decides, the Supreme Court decided that it's not appropriate for domestic courts to determine whether the UK has violated its obligations under unincorporated treaties such as, in this case, the UNCRC, the United Nations Convention on the Rights of the Child. It's a fundamental principle of our constitutional law that an unincorporated treaty does not form part of the law of the UK. And of course that is the case, but there had obviously been attempts, piecemeal attempts, to get that convention stuff, not just in relation to the UNCRC, into domestic case law, and that obviously, that decision in SC, it felt to me like a big crowbar. Secondly, the court clarified that a low intensity of review is generally appropriate in cases concerning judgments of social and economic policy in the field of welfare benefits and pensions. And when they mean a lower intensity review, they mean obviously that it's much harder for claimants to prove their case in welfare benefits cases. So in other words, the courts will generally accept the judgment of a legislature or the executive that a difference of treatment is appropriate in that field, unless it is manifestly unreasonable. And many of us have been working over the last few years to try and make inroads into that manifestly without reasonable foundation bar that has been set by case law many years ago, and we've been making progress, but that kind of restating of the law has kind of gone back to making life extremely difficult in relation to welfare benefits. And thirdly, the court considered the use that could be made of parliamentary materials when considering whether primary legislation is compatible with convention rights. For me, this is was a bit of a killer to read. So material placed before the Parliament and statements made in the course of debates may be relevant as background information, but material of that kind may also be relevant in demonstrating as a matter of fact that issues bearing on proportionality were considered by Parliament during the course of the legislative proceedings. Nevertheless, the proportionality of a statutory measure is not to be judged by the quality of the reasons advanced in support of the course of the parliamentary debate or by the subjective state of mind of individual ministers. And so the court concluded that two-child limit has an objective and reasonable justification, notwithstanding its greater impact on women. So basically a Parliament pass and enact a unfair and discriminatory system because Parliament passed it, then there you go. And for me, as a kind of somebody who's been working in the human rights world and also as a single mother myself, that was felt like a huge step backwards and a really sort of damning indication of where we're up to. I'm gonna really, I promise, like last 2 points. So in an interview with Dinah Rose QC last Friday, Lord Reid said, do you feel pressure? And sorry, Dinah Rose asked, do you feel the pressure? Is the court retrenching? Is that a fair response to your recent judgments? And for what it's worth, Reid replied, no, I don't feel the pressure. When government has overstepped the limits of legality, we don't mess about telling them about that. We have been very clear. If it is within their domain, we are saying we are not going to intervene because we recognise this is within your domain. If they have overstepped the mark, we are saying get your tanks off our lawn. So it's clear. So it is clarity of communication really in response to the expressions of concern. I'm not going to say anything about that. So genuinely last point is, as well as kind of the amount of kind of legislative reform, the kind of change in change in judicial decision making, we've also had a huge raft of procedural reform to cope with, and lots of it has gone under the radar. We know that there's more coming through the CPR committee, questions around their transparency, their kind of their non-consultation approach, and how we can influence them and explain to them our clients' experience of the judicial system and the admin court. There's a focus on procedural rigour from the administrative court led by Justice Swift, which has often for claimant lawyers felt like we are coming under heavy criticism, including reports to regulators for allegedly not complying with the rules, having a chilling effect from a kind of unexpected quarter. And we've also had massive changes in the way that interveners have to front load their applications for interventions. So altogether, kind of massively restricting their access to the courts. I'm really sorry for overrunning. Thank you.
No, that's fine. Thank you so much, Sara. I think all really important as it cuts through kind of all of the issues that anyone working in human rights law does. So really, really insightful and quite terrifying, the depths this all goes to. But just before we wrap up, I have a few questions for the panelists. We've got one question in the Q&A box from the audience that I'll try to get to, but if anyone else has any other questions, please do post them in the Q&A box and I'll try to get through as many as possible. The first question I wanted to ask each panelist is, what do you think is the single biggest threat to upholding human rights in the UK at the moment? So I know it's a very broad question, but what do you think is the single biggest thing that perhaps you on a personal level as a lawyer feel most terrified about with everything that we've discussed? So I'll maybe go to Raj first to answer that question.
The political answer is this government, because they are the most authoritarian and tyrannical government in terms of allowing challenge that I've seen during my career. And I think you've seen the broad range of challenges across what all of the speakers have said. So I think that's the simplest answer. Appreciate as lawyers rather than the political arena. In my field, it's clearly the new bill and where we go with that.
Thank you, Raj. And I'll go to Toufique next.
Yeah, I mean, I echo Raj's comments, and I mean, I'd say it's the tyranny of the majority, isn't it? You know, it's the problem is the government is, you know, feels it, you know, its power, its ability to be authoritarian comes, you know, derives from their majority in Parliament, and that's why we're seeing these inroads into liberties. So really, I think it's up to us, and it's up to people to change the narrative so that, you know, because I think in the last few years the narrative has been filled with so many lies and so much hate, and so the public needs to have a better understanding of the truth. That's the only way really to change the way in which the government that, you know, Raj rightly talks about, you know, gets them out of power, so that they're not able to pass primary legislation that allows them to act in a way which, you know, ironically, it's powered by democracy, but ends up being oppressive and authoritarian.
Absolutely. And I'll go to you, Sara. And I also note that there's a question for you in the chat. So maybe you can just, I'm not sure if you've addressed that in writing. Yes, you have. Okay.
Yes.
So yeah, if you can just answer that question then in terms of what you think is the single biggest threat.
Yeah, I mean, just to kind of give a bit of variety to the answers, I'd sort of say so probably something around like transparency and oxygen. So something around how, you know, obviously this government have a huge majority, and so it's relatively easy for them to push through actually like very troubling kind of, you know, reform. And I think part of the problem, apart from the obvious issues about you know, being voted in the first place, is around kind of getting oxygen to the issues and countering the kind of really aggressive kind of media anti-immigrant, anti kind of anti-difference kind of narratives. I think it's really hard, even when, you know, you've got a good lift cell on your case, that you know, getting the kind of oxygen than other than like in a couple of quite kind of narrow outlets, and kind of getting people engaged is, I think, a really massive challenge.
Absolutely. So the next question I have, I will direct towards Raj first. But in light of what we've sort of discussed about the changing face of the judiciary in a lot of ways, some of that being good, some of it being challenging, do you think we can successfully rely on human rights arguments in the courts to mitigate against some of the most draconian aspects of the policing bill if it passes as it currently stands?
I do think that there is a chance of that. I'm slightly more optimistic than some of my colleagues about it, but it sort of depends on how the judiciary react and at what level, because I think that the Conor Garrity article from the LRB that Toufique's mentioned is absolutely fascinating as a general review of how convention rights cases have been treated by the Supreme Court. And despite his answer that Sara quoted, it does seem as if there's some sort of retrenchment and more discretion is given to decision makers. And what that means in terms of the bill is how the lower courts are going to start to interpret it as well. Because the second certified question in Ziegler related to the appellate courts only overturning lower courts' decision if it was a decision that no reasonable judge could come to, rather than what the High Court said, which was if convention rights are engaged, if the decision is wrong. So that on convention rights, it gives more latitude to the lower courts and seems to fit with the sort of Reid ethos that you give more discretion to the decision maker before you overturn something. So I'm fascinated to see how different levels of the judiciary react to the new bill.
Yeah, absolutely. And I'd ask Toufique the same question. Do you think we can successfully rely on human rights arguments to mitigate against some of the most draconian aspects of the Nationality and Borders Bill, given your work? Oh, I think you're on mute, Toufique.
Sorry. Yeah, I'm hopeful. I mean, I use a recent example of one of our cases of Van Riel versus Secretary of State, which was a recent Windrush case where, you know, the courts did effectively use the Human Rights Act in terms of its, you know, Section 3, where you're supposed to, as far as possible, primary legislation needs to be read and given effect in a way which is compatible with convention rights. And in that case, the judge decided that the British Nationality Act did contain discretion to disapply the 5-year rule that allowed a Windrush victim to qualify for nationality. And so I think the way forward is to try and really use that and to try and persuade the courts down the road in terms of when indeed in the context of the nationality bill, whether or not the legislation is compatible with convention rights. And I think that's where a lot of it lies.
Absolutely. And just to follow up on that, we have a question in the chat that mentions that, you know, the government's also undermining refugee status protection by reducing the definition of serious criminal to a hopelessly low threshold. And the UNHCR has highlighted in its review of the Borders Bill that particular issue. So the audience member has asked whether you have any thoughts on this, and I guess it's connected to what you've said about kind of interpretation and how we can use that in the courts. Yeah, and it consistent with the Nationality and Borders Bill being, you know, the biggest assault on international refugee law that I think we've ever seen, and their desire to really create a system where refugees and people seeking asylum are treated differently. You know, they're looking to lower the standard of proof, to amend the standard proof when it comes to persecution. They're looking to punish people for their mode of entry, and they're looking to catch more people in terms of a deportation net than they currently can. Absolutely.
And also, can I just add on there is also the point that by doing all of that, they're obviously putting judges at risk of putting setting judges expressly against their kind of policy aims, you know, and it's kind of actually like huge politicization of kind of judicial decision making. It's like inevitable. Yeah.
Absolutely. So just before we finish up, I've got just a couple of questions left. The first question is just in terms of, to end on a positive note, I'd just like to know from each of you, what is your biggest human rights win in the last 12 months? So what's the thing you're proudest of in the work that you've been doing? So let's start with Sara.
Well, the one that I'm proudest of, I don't think I can share just yet. Which is really annoying. Yeah, well, anyway, there's going to be something coming out soon about that. other than that, my own personal casework, really pleased. One of the challenges, one of the sort of system challenges that I brought against the Secretary of State for Work and Pensions, by which benefit claimants, disabled benefit claimants, were being cold called and pressured into accepting a lower offer on their statutory entitlement. It's happening over a period of years to thousands of people, and Secretary of State sort of flatly denied it, etc., and conceded the case on the first day of trial, and it just has made you know, a massive difference to all of the people that would have been pressured kind of into receiving, you know, so much less money than they should have, and kind of being left in really sort of terrible conditions. So yeah, that's a nice win.
Amazing. I'll go to Raj next.
I think Ziegler probably, but it allowed the path to the Colston trial, and that moment when the jury came back and said not guilty is a highlight, and it was a great case just because it highlighted so many of the issues that people want to talk about from Black Lives Matter or beyond, in relation to the legacy of slavery, legacy of imperialism and colonization. It really was just a great moment.
Absolutely, and I think for everyone who was waiting for that verdict as well. And Toufique?
Can I say Raj's case? Brilliant, amazing stuff. But in terms of our work, I think probably we've had a few decent victories last year. Probably the one that stands out, just because of the difficulty in trying to, you know, establish that detainees in prison were being treated differently to those in terms of legal access to in those in immigration removal centres, just because the optics of it, of obviously representing FNOs and bringing the case and winning on Article 14, which is pretty difficult, and doing it in the way we did was probably my highlight.
Amazing. Okay, well, we've gone a little bit over time, and I know we have to get to the AGM, but thank you all so much for your time today and for your amazing insights and reflections. I hope everyone has enjoyed it this evening. I definitely have. And yeah, I think we look forward to seeing what you all do in the year to come as well.